So the quick and dirty answer is the teacher can use that as a punishment. There's not really any way to preclude that happening. What you should do is go have a meeting with the teacher. So let's jump in and talk about discipline. Why would you want to know about discipline? I was asking myself this question. And I think the reason is because, many of the listeners have multiple children. Children are of different ages. And unfortunately, some of those children, whether they have an IEP or not, are going to get in trouble at school. Nobody told me what the rules were. So, I'm assuming that you only have a vague notion of what isn't permissible. So that's why we're going to talk about discipline. And like a lot of things we talk about on this program, there's different rules that apply for people with IEPs than people without. So I'll be making those distinctions. So first of all, you get into the subject of what is, permissible classroom discipline. And don't laugh at me because I'm so old, but corporal punishment used to be permitted and it isn't anymore. You cannot use physical punishment to control kids in the classroom. We're talking general situation now, regular ed kids as well as special ed kids. The exception to that would be if a student is using force in a manner that's going to hurt him or somebody else, then, you are right to use restraints and punishments, like containment, may come into play. But generally, there's not going to be any physical or corporal punishment for good reason. We've learned over the years that corporal punishment does not ultimately work to produce the desired result. So you cannot impose an in-school detention or suspension, but you can't do it at lunch or recess. And you can't do it for more than 1 hour after school. So that was something I didn't know. We all hear sometimes about, in-office suspensions in the nurse's office or the principal's office. Suspension generally is covered in California by Education Code 48900, and as well as is expulsion. And I thought I would actually talk about the statute, even though they'll be different in your different states or internationally. I think it gives you a framework for what you can expect. So the general notion is if you cause or attempt to cause physical injury to a person, you possess a weapon or a dangerous object, you are under the influence, you damage school property. Interestingly, if you possess or use tobacco, if you steal or damage school property, if you sell drug paraphernalia, if you, severely disrupt school activities, then you are going to be subject to suspension and potentially expulsion. And then we also get into an interesting question, well, what about those activities that have a nexus with school but they don't occur at school? And immediately we think about things like cyberbullying or, drug use at a party, or something that happens on the way to school. And the answer is the question of whether and how the people can be disciplined is going to depend on the nexus with school itself. So those are really kind of fact-specific situations. Now, you can be suspended for up to 20 days in a school year and 5 days consecutively if you're a general ed student. And if you're a special ed student, you can be suspended for up to 10 days consecutively. And I asked myself, why would it be longer for special ed kids? And it seemed to me that the policy reason had to be that special ed kids were harder to place, both, coming and going. And they cannot be suspended for more than 10 consecutive days or 20 days in a school year. Now, if you are suspended, you do have due process rights, but they're kind of limited. Generally, you're not going to end up with a real appeal in front of an administrative legal body. You're going to end up with some kind of school procedure, whether it's an appeal to the superintendent or it's an appeal to the governing board of education. And I think it'd be fair to say in those situations, it might be hard to get a fair shake. But there are some limited appeal rights, and generally, if you have one of those appeals, you're going to have the right to see what the evidence is against you, present your own evidence, possibly put on your own witnesses, but it's not going to be procedurally and sort of constitutionally like a real trial. It's going to be basically the school is largely making the rules. Now, Sometimes you have an opportunity to appeal those school board decisions, and sometimes you don't. But generally, if you do, you're going to have to quickly appeal those kinds of decisions. And different states are going to have their own laws as far as what statutes come in play. In California, you have the governing board or the superintendent has 5 days to decide and notify you, and then it goes from there. So if they decide not to expend or if they decide not to suspend or expel you, everything has to go back to status quo. You are allowed to return to your placement, and there shouldn't be any punishment, and everything should be stricken from your school file, because essentially you were accused of something that they found you didn't do. Now, there's also supposed to be a post-suspension conference with parents for situations when the suspension is upheld, but there's no punishment that I could find for failing to attend that conference.